welcome.
Thank you so much. My name is Janson Wu, and I'm an attorney with Gay and Lesbian Advocates Defenders, which is a New England-based legal organization dedicated to ending discrimination based upon sexual orientation, gender identity, and HIV status. Through my work, I've worked extensively on marriage equality throughout the country and in New England, and have a vast knowledge about the state of the law in many states, and we're happy to answer any questions about that. I want to focus my testimony on 2 points today, however. The first is that Section Senate Bill 38 and current Rhode Island law already provide appropriate and common sense religious exemptions. And the second point that I want to talk about today is about Section Bill 708, which goes too far in weakening our state's anti-discrimination laws and would harm a broad range of married couples, not just gay and lesbian married couples, and their families. So to the first point, Senate Bill 38 and current Rhode Island law provide broader exemptions for religious organizations than any other state in this country that allows gay couples to marry. And let me just repeat that one more time. Senate Bill 38 and current Rhode Island law provide broader exemptions for religious organizations than any of the 9 states that allow gay couples to marry. Now, how is that possible? It's because beyond the explicit exemptions that are in Senate Bill 38 for churches and clergy with regards to the solemnization of marriage, current Rhode Island law already has an exemption, a complete exemption for religious organizations in our sexual orientation anti-discrimination law. What that means is no religious organization need comply with our prohibitions against discriminating against gay and lesbian people in this state. And so that is an incredibly broad exemption. It's one of the broadest in our country. And even if that were not ample or broad enough for religious organizations and the protection of religious liberty, but Rhode Island also has a Religious Freedom and Restoration Act, or RFRA, which provides additional protections and greater protections than the federal Constitution does, actually, for any entity that may not even qualify for a religious organization. In contrast, Senate Bill 708 ultimately has nothing to do with our marriage laws in the states, but rather dangerously weaken Rhode Island's anti-discrimination laws that have been in place for decades. Let's take one example. Senate Bill 708 would actually provide exemptions to individuals who are entirely unaffiliated with any religious institution to discriminate against any married couple based upon their individual religious belief. This is something that we have never done before in the history of our state, and there's good reason for that. First, it wouldn't just harm same-sex couples, but a broad range of married couples. And we should never forget that religious objections to extension of rights to marginalized peoples is nothing new. There have been religious objections made to interracial couples marrying, interfaith couples marrying, people marrying after divorce. And so what Senate Bill 708 does is set up a slippery slope in our state that we just do not want to go down. Will the Protestant baker then be allowed to refuse to bake a cake for a Catholic or interfaith wedding? Would a landlord be able to refuse to rent out a home to an unmarried couple because he believes they're living in sin? The answer is no, because there's just too much diversity in religious beliefs in our country today to allow any individual to pick and choose which laws they want to obey based upon their individual beliefs. And in fact, Chief Justice Scalia, a conservative and Catholic justice on the Supreme Court, in one of the seminal religious liberty cases, Smith, actually said that allowing any man to become a law unto himself would undermine the rule of law and create legal chaos. There would be no way for us to enforce laws of general applicability. The last thing which I just want to do with my remaining time is just to kind of sweep away a lot of the fear tactics that we've heard tonight from the other side, with examples about the Lexington School District or Catholic Charities. The point of these examples is they actually have nothing to do with our marriage laws, but rather our anti-discrimination laws. Catholic Charities was about whether or not an adoption service agency would allow same-sex couples to adopt children in need, regardless of whether they were married or not. Lexington School case was, again, about whether or not schools would be able to teach kids and their students about the realities of the lives of the world that they live in, regardless of whether or not same-sex couples are allowed to marry in their state or not. And I think the best example we've heard tonight from the other side is the New Mexico photographer example, where the couple that did sue the New Mexico photographer wasn't even trying to get married. And New Mexico doesn't even allow gay couples to marry. Ultimately, what the objections are about are not with gay couples marrying, but with gay people in general. And we should not allow this marriage equality bill to undermine the important anti-discrimination protections that we've had for years in the state. Thank you.
Are there any questions or comments for this witness? Senator Conley.
Thank you, Mr. Chairman. The laughter behind you is because I'm usually not known for asking questions. So
I'm honored.
That's what the laugh is about. It has nothing to do with what you've had to say. First of all, I want to say thank you for your testimony focusing on the religious exemptions issue, because one of the things the committee is confronted with tonight is evaluating, two bills which actually do acknowledge gay marriage in the state, but have, I think, the significant differences are the procedures under 708 and the religious exemptions provided therein. So I'd like to, if you don't mind, I'd like to ask you a few questions about the religious exemption issues that you've touched upon in your testimony.
Yes.
At first blush, when one looks at 708 and what I'll refer to, for lack of a better word, as the solemnization exception that is built into the law, compares that with all the other states that have essentially included religious exemptions, and I'm sure you know them well, the Connecticut, District of Columbia, Iowa, Maine, Maryland, New Hampshire, New York. Well, I don't want to leave anybody out now that I've started, Vermont and Washington. At first blush, when you look at those religious exemptions, they seem to be, on their face, more robust than the religious exemptions contained in 38, that's Senate 38. Now, you began in part to explain why you think under our current Rhode Island statutory scheme, Rhode Island actually already has more robust religious protections. Could you elaborate on that a little bit? Identify where in Rhode Island law you find that, and why legally you believe that is actually a more robust protection for the religious exemptions.
Absolutely. And that's the reason why Rhode Island does have more robust protections already in place, is because none of those other states have what Rhode Island has, which is Section 11-24-2.1, subsection H, which is actually the definition of sexual orientation. So at the time that Rhode Island added sexual orientation as one of the classifications that would be protected in our anti-discrimination laws, they went ahead and defined sexual orientation, and within that definition explicitly said that this would impose, quote, would not impose any duty on a religious organization. None of these other states that have passed marriage equality have this blanket exemption, and that's why Rhode Island already has the ample and common sense protections for religious organizations.
Can I ask you to look at, to sort of respond to how you think that statute applies to a scenario that a lot of people have talked to me about in the past few weeks, for instance. We all agree that 03838 contains the solemnization exemptions. You've identified other sections of Rhode Island law that you think also add sort of a level of protection. One of the things I've been asked is how under those laws would the kind of following scenario be, how you think at least how the following scenario would be addressed. A lot of people who are faced with challenges in their life turn to their faith as a way of trying to meet that challenge. And let's take challenges in their marriage, for instance. And a lot of people have talked to me about when they've confronted challenges in their marriage, they've turned to their pastor, their minister, for marriage counseling. And I've heard some concerns expressed to me that a cleric in the capacity as a marriage counselor would not be protected by either of the Rhode Island laws you have cited or 38. Do you have any response to that? Any thoughts on that?
Certainly. And I think the first thing that's important when you consider any hypothetical situations is that, of course, the courts will ultimately answer a lot of these questions.
Absolutely.
Right?
And I understand that.
Yeah.
But because it's a concern,
Yeah.
I'd like to
Sure.
at least try to think it through.
So I think the first question you need to ask yourself is, are these activities even regulated under the law already? And, what's regulated under our anti-discrimination laws are employment, housing, and public accommodations. And so, it would be hard to make an argument that a clergy who is providing counseling to one of their parishioners on marriage is providing a public accommodation at all. So that would be my first initial answer there.
Yeah. So you would agree with an analysis as that you've focused on tonight, that kind of an activity, again, within a clerical forum, providing that counseling, would essentially still be protected because of the other sections of Rhode Island law, even though it might not be clear in 38.
Yeah, for something to be regulated as a public accommodation,
Right.
it actually has to be
Right.
public and has to be put out there in the public marketplace. And it's hard to imagine that is what clergy in our church is doing.
Now, you've explained why you have some concerns about, for instance, the proviso in 708 that deals with, say, small businesses. And so this may not be a fair question in the sense that it goes on, but what you said goes beyond your analysis, and maybe you feel you don't need to reach this level in your analysis. But again, on that side of the question, one of the concerns that people have talked to me about is, in that context, is it possible to distinguish when somebody refuses to, again, to use your bakery example, somebody refuses to provide baked goods in the context of a same-sex marriage ceremony? How do you distinguish between whether or not that refusal is based on some kind of discriminatory animus, essentially an anti-gay animus, or whether it's based on a good faith, deeply held religious belief? How would you make that distinction in those circumstances?
Well, there's doctrine that courts use to try to ferret out what is in a person's head, right? And there's challenges in trying to figure out what a person's intent is. But I actually think this goes to a really more interesting point, which is that the individual exemptions, beyond honestly being incredibly offensive and harmful to our anti-discrimination protections in our state, could actually backfire and have the opposite. So when businesses believe, and I would say falsely believe, that they can do whatever they want when a gay person walks into the store, this law is actually inviting businesses to put themselves in liability and create risks that may not actually be protected, and that would ultimately still lead to litigation. And so the reason why we have laws of general applicability is because they're clear. They give notice to businesses what is okay and what is not okay, and then employers and businesses then can conduct their businesses and avoid liability. All these exemptions do is create confusion.
In referencing the other areas of the Rhode Island law that you did a moment ago, would you have any suggestions on how we would, if you think it's required, on reconciling either one of these proposals before us tonight with those sections of the Rhode Island law, or would it be your position that they are already homogeneous and work together? And if so, if they're in harmony, can you just explain to us why?
I think that Senate Bill 38 already provides the ample and common sense protections alongside with the current Rhode Island law. And I think that the reason why I stand in firm opposition to Senate Bill 708 is because I don't think that creating specific, explicit carve-outs to the law is a very good way to make policy on something as important as anti-discrimination. These are hard issues that we have courts to kind of wrestle through, and they're fact by fact. what has been working in Rhode Island, what we have in Rhode Island currently has been working for decades, despite religious objections for the entire history of our country with regards to civil rights. And we shouldn't be messing with that today simply because we're now considering allowing loving gay couples to marry as well too. I would just add though that to the extent that there are broad exemptions already in Rhode Island law, certainly that is not justification for allowing certain entities, or that's not an excuse for allowing certain entities to discriminate. Discrimination should be wrong. It is wrong. It is harmful to families. It's harmful to children. And so this should not be seen as an invitation for us to treat anyone unequally.